Welcome back. It is 20 till 7 here on your Friday morning. You ever wonder why some charges or defendants get kind of lumped together in a court case while others stay separate? Well, we are finding out today for Legally Speaking. Attorney Dave Betras is here, as always, on a Friday. Good to see you, my friend.
Good to see you. It's good to be here. It's Friday. It's Legally Speaking. Malena. I did it right. No more donations to charity. Anyway.
Well, I learned a new legal term when we were talking yesterday, joinder. I had never even heard of that one.
Right. So there's two types of joinder. There's joinder of indictments against the defendant. So one defendant, multiple counts, they join all the counts into one indictment. And then there's a defendant indictment. So you and I go out and rob a bank, and they join us together, and they're going to try us together, okay? So the court on its own can relieve joinder if the court makes a determination sua sponte or on its own that that is prejudicial to either the defendant or to the state of Ohio. Judges rarely do that because they want to move their docket. You know, judges have a docket, meaning cases on in their courtroom. And their job is to move those cases. As a matter of fact, Supreme Court of Ohio says every criminal case, you got to kick it within 6 months. So they are putting pressure on trial judges to move cases through the system as quickly as is humanly possible. Now, if you have two defendants joined together, you can file a motion for relief of what they call prejudicial joinder. So a defendant could file a motion and say, hey, judge, it is not fair to my client to be charged with this other defendant, and there are certain rules under which a judge must sever the case. I'm just going to throw out a case called a Bruton problem. Bruton is a United States Supreme Court case saying if you're trying defendants together and one defendant gave a statement and one defendant didn't give a statement, then the court must separate those because that statement against the co-defendant comes in, but the other defendant doesn't get to cross-examine that. So that's one time when it's a mandatory severance for defendants. The second way is, say you go out and you commit a crime spree and they charge you with 5 crimes and then they indict you and they want to charge all 5 crimes. If you can convince the court that there's some legal reason or some prejudice to you that will materially affect or could materially affect the outcome of the case, they can give you that relief from joinder. Think of it this way. If crimes are committed together and defendants commit crimes together, those are pretty much going to be joined. If you commit a crime on Friday and 2 weeks later you commit another crime, the prosecution could join those if they want, or you could ask for a separation. So a lot is on the prosecution's office or the United States attorney on how they indict the case and why they indict the case, and whether it's going to be one trial on one count in the indictment or multiple trials on multiple counts.
From a defense attorney's perspective, then, are there like advantages or disadvantages to having it one way or another?
I hate to say this, but I want it both ways at all times. Let me tell you why.
Okay.
If I am a co-defendant with someone else and there's a whole lot of evidence against him and there's not that much against me, I want to get tried with him because the jury's going to look, wow, look at all the evidence. This is what they must mean to make it. And so that's a case where I might say, oh no, the prosecution might want to separate them. I go, oh no, judge, we'll sit here. I'll let the co-defendant's lawyer get up and explain why his client did X, Y, and Z and why my client did nothing. So that's one reason why you'd want it. Sometimes the prosecution gets it wrong. I tried a RICO case some years ago where they had a whole bunch of evidence against my client, not so much against the other guy. Jury found my client guilty. They found the other guy not guilty. But had the United States attorney tried them individually, they both would have been found guilty.
Wow, that's really interesting. Yeah. I feel like we learned quite a bit. And he brought the supplies this morning from Landmark.
Our friends at Landmark. There's the stamp. See? Oh, I wish I'd have opened the boxes. You should see how good those donuts look.
Oh, they do.
They're like homemade.
I've seen the boxes open. They look good.
They look good.